any misconduct of the state. And again, I haven't found here any misconduct of the state. However, procedurally, disclosures were late and deadlines were missed. On weighing the facts of this case then against the rights of the defense to have an objectively reasonable time to prepare for a death defense, the court determines that the late disclosure of discovery has materially prejudiced that right. The court also notes that this is not the result of a single discovery violation, but rather the cumulative effect of a deluge of discovery coming too close to trial, culminating in a large discovery disclosure a day after the scheduling order mandated, and finally even more discovery that was not provided to the defense until, according to the record, March 13th. The defense cannot be required to review that quantity of new discovery only 2 weeks before jury selection begins. This has prejudiced the defense. I've cited the affidavit of the mitigation person who has said unequivocally they simply cannot have time to prepare and go through for mitigation the late disclosed discovery. Thus, considering everything, the court is required to fashion a remedy that honors the rights of the parties, the fundamental right to a fair trial, and the right of the state to bring to trial those who are accused of a crime. In balancing these rights, the court concludes here that as an appropriate discovery sanction, the state will be precluded from seeking the death penalty at trial, and the state's May 2nd, 2022 notice of intent to seek the death penalty will be stricken. To be clear, the court does not impose this sanction to penalize the state, but rather to ensure the constitutional right of the defendant is protected, allowing for a reasonable defense to be prepared for this trial. In addition, this court will keep under advisement any further objections that may be lodged in the form of motions in limine that will come either before or during trial to consider whether any late disclosed evidence should be excluded in an attempt to remedy the prejudice that may have resulted from these late disclosures. Finally, a couple of points on that decision. There was a late filed emergency motion yesterday that related to this. The court had reached this determination and determined this to be the appropriate remedy prior to reviewing that, and in fact did not consider any of the issues raised in yesterday's pleading in making this determination, and I'll consider that pending motion moot. I'll also note that the ruling here applies only in this case against Ms. Vallow, the 1624 case, and in no way impacts or affects the companion case 1623, because that defendant has been provided additional time to prepare for trial and to review additionally disclosed discovery, so it has no impact on that case. So with that concludes the court's oral ruling on the motion to strike the death penalty. Granting that, the court will issue an order to that effect. The court will also be issuing orders that relate to the constitutionality of the death penalty motions that are pending, which will be resolved in orders submitted either today or tomorrow. The court will be available to counsel up until Thursday here. After that, I'll be in Boise for the getting ready to commence trial next Monday. And if counsel needs to reach out in terms of any administrative or planning procedures that change as a result of this decision, I'll do my best to make myself available. That will conclude the ruling for today, and the court will be in recess.
All right.